Okay, please raise your right hand and swear from the contents of the report are true to the best of your information and belief.
Yes, I do.
Thank you. I have one count of assaulting, resisting, obstructing a police officer, one count of domestic violence, second offense. Looks like the first offense is from 2004. And then I've got a 2006 conviction for second degree. All right, go ahead with your testimony, please.
Your Honor, on 12/14/2023 at approximately 22:54 hours, Sergeant Moss, Corporal Beggs, and Officer Hunter of the Flat Rock Police Department were dispatched to 2405 Mayfair Drive, Building 7, on the report of a domestic dispute. Upon arrival, officers heard a female voice from inside the residence yell, "Get off me," followed by what sounded like a struggle and numerous thuds. Officers spoke with the victim, Sarah Elizabeth Helen Murilli, who peeked out of an upstairs window and was crying and emotionally distraught. The suspect, a live-in, current, and former intimate partner and boyfriend, who was identified as Timothy Roy Knoll, could be heard loudly yelling inside the residence at Murilli. Knoll was yelling for Murilli to tell the officers that everything was fine. Officers attempted numerous times to get Murilli to come out the door. Although she continued to stay, she could not and would apologize. Sergeant Moss and Corporal Beggs both observed Knoll locked in the doorway, preventing Murilli from going outside with officers. Corporal Beggs and Officer Hunter then personally observed Knoll grab Murilli by the arm and physically push her outside. Knoll immediately shut the door behind her and locked himself inside. Murilli then fled on foot from officers and was apprehended a short while thereafter by Corporal Beggs and Officer Hunter. During the foot pursuit with Murilli, officers observed Knoll flee the residence and run to a nearby wood line. Sergeant Moss and Corporal Beggs, who were wearing a navy blue Class B uniform with Flat Rock police patches affixed to both shoulders, outer collars with silver badges on the left and police written on the back, gave pursuit on foot behind him. Officers located Knoll lying down in the wooded area and began giving him verbal commands to stand up and place his hands behind his back. Sergeant Moss then grabbed Knoll and he began to resist arrest by pulling away. Sergeant Moss deployed his department-issued OC spray one time into the eyes and face of Knoll. Knoll continued to pull away and resist officers, refusing to place his hands behind his back. After a continued struggle, officers were able to place Knoll under arrest for domestic violence and assault, resist, obstruct an officer. The report was forwarded to me, and I forwarded it to the Wayne County Prosecutor's Office for reviewing the charges which you now see in front of you. And it should be noted, as discussed prior, Mr. Knoll does have a previous conviction for domestic violence from the Dearborn Heights Police Department out of the Third Circuit Court, where he pled guilty on 1/16/2004. And he also has a prior felony for homicide, murder in the second degree out of the Lincoln Park Police Department and Third Circuit Court, where he was found guilty on 6/9/2006. Nothing further, Judge.
Thank you. I do find probable cause to support the charges. We'll move on to the arraignment portion. Attorney Reagan.
Yes, Your Honor.
All right. You ready on Knoll?
Yeah.
Flat Rock?
That's what that again, Your Honor.
Sorry.
Ready. I am ready.
Okay. All done. All right, what's your name, please?
Timothy Knoll.
Thank you. People versus Timothy Knoll, counsel.
Reagan, on behalf of Mr. Knoll, Your Honor, waive the formal reading, stand mute. He's been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. I'll hear your argument as to bond.
Judge, so the court has already been apprised of my client's priors. He does have a 2004 DV and a 2006 second degree case. Now, he's been out of prison, Judge, for the last 7 years. He's been working, doing heating and cooling. He makes a good living doing that, Judge. Judge, and I would be really concerned, Judge, if the DV was a little more, closer in proximity. Now, 2004 is over 20 years, or about 20 years ago. Obviously, he did prison time for the homicide case, Judge, which I don't have information on the facts of that case, which, do make a difference, I believe, Judge. But Judge, what's kind of interesting to me, when I heard the officer reading in the report, that the complaining witness, she comes out of the house, police are right there, and she starts running away from the police, and they have to chase her, and at that time, that's when Mr. Null comes out and he goes his way. I do see the R&O, Judge. I mean, in terms of the probable cause, it was just a little confusing on why the complainant wouldn't come out the house, talk to police, and deal with police at that time. But regardless of that, Judge, we do have the charges here. It's a misdemeanor, punishable up to 1 year. We do have the R&O. It's another high misdemeanor or a low-level felony, punishable up to 2 years. So, Judge, regardless, this is the arraignment stage. We're not here to punish. We are here to make sure that my client comes back to court, and we are here to ensure the safety of the community. I don't think that the police are in any danger from Mr. Null, because the police can handle themselves very well, Judge. Now, we have to look at Miss Merrily. Now, if you tell him to have no contact with her, it's not going to have contact, Judge. I think that would suffice in this particular situation. Again, Judge, since he's been released from BOC, there have been no situations of domestic violence to my knowledge. There have been no issues to my knowledge. I don't know what happened that day, what set them off. But it'll come out later in court proceedings, Judge. But while we're waiting for those court proceedings to matriculate, I'm going to ask respectfully for a personal bond for Mr. Null. And whatever conditions the court wanted to impose, we'd have no objection. But again, Judge, I would ask for that. I do understand, the R&O situation was a little bit, tumultuous in terms of going in the woods, in terms of having to spray him. I get that, Judge. But again, it's a 2-year felony and probably wouldn't do a day in jail if he was to plead on it, Judge. So I'm asking the court not to keep him in jail now and to set a high personal bond with whatever other conditions the court wishes to impose.
Thank you. There are a couple of areas of the investigator's report that I want to make sure I'm referencing, because they do influence my bond decision.
Mm-hmm.
The first
Mm-hmm.
is upon reviewing the interview conducted with Ms. Merrily, she stated she was running from the suspect and not the police out of a fear for her safety. That's the first thing that concerns me.
Okay.
Now, the second thing, she was asked if she wished to prosecute Null. She was unsure and could not provide a definitive answer. She stated that she loved him and believed he needed help. So now that starts to frame what I'm going to talk about next, which is she says they've been in a dating relationship for approximately 5 months and living together 3 to 4 months. She says, quote, "This has been ongoing and progressive. She's been in abusive relationships in the past, quote, but nothing like this." That, spoken by a person who claims to still love someone and only want them to get help, tells me this is not about fabricating.
Judge, I don't think it's
I'm sorry, we're being rocked by a bass concert. I don't know what's going on over here. Just give me a minute. I can't even concentrate.
Yes, Your Honor.
Okay, thank you. I don't know what that was. All the car alarms are going off. That coupled with a prior misdemeanor domestic violence 2 years before a conviction for second-degree murder causes me great concern for the complainant's safety. And so while I just imposed an extraordinary personal bond in a home invasion first case, here I'm going to impose an extraordinary cash bond in a misdemeanor case, because I do believe there is clear and convincing evidence that this complainant is in danger. And I'll go on. It's the police who arrived at the house and were trying to get her out. And she's apologizing to them and crying and saying, "I'm sorry, I can't." She's not allowed to come out of the house. And then when she finally gets out of the house, they observe bruises all over her legs, at least to her legs. All of this lending to the credibility of her statement that this was an incident of abuse. And my concern, given the prior record, is how this might escalate. So I am setting a cash bond that is intended to keep Mr. Null in custody. until he sees a judge the next time. And while you're right that he may not receive jail time, I don't know how cooperative the complainant's going to be. There's stuff going on in the file. It's possible. It's possible. Jail time is possible for misdemeanors. So maybe he'll be earning credit. But at this time, I am setting a bond at $300,000 cash, no surety. I do realize it is an extraordinary bond in a misdemeanor case, but given the prior convictions, I have great concern for the complainant's safety.
Judge, may I say one more thing? And I never want to interrupt the court while the court is talking. And I appreciate the court, Judge. You know, and we talk about the prior convictions being 20 years ago, Judge, or around that time. And Mr. No did do time in prison for the second degree. I don't know the circumstances, Judge, but my thing is, you know, I don't know Mr. No, Judge. I do know what the investigator's report talks about, and I do understand what the court says about temperament, about, you know, arguments, and about, you know, her not necessarily wanting to prosecute, but wanting him to get help. Mr. No may be an aggressive person, Judge, may have an aggressive personality. They may argue a lot, Judge, but that doesn't mean that if the court says have no contact with her, that he's going to have contact with her. Again, Judge, I don't want to presume him guilty.
The police ordered him to let her out of the house. The police were right there ordering him to let her out of the house, and he didn't. Why would my order be any more convincing? A piece of paper from here. I do not believe it is. I don't think I'm more convincing than several police officers standing outside of a home saying we need her to come out and her not being allowed out. I don't think my piece of paper is more convincing or has any more control over that behavior.
I understand. I think that when you were in a position at that time, your actions, your adrenaline, your emotions, he was acting, Judge, at that time. Now we have an opportunity to sit down. He's been sitting for 3 days in jail. You give him the order now not to go back, can't go back there, Judge. And if you put a tether on him, if he has any contact, then you know, all bets are off, Judge. So I think time is the difference, Judge. Time.
Mr. Reagan, with all due respect, he did a bid for second-degree murder. He had a whole lot of time to sit down and think about his behavior and level of aggression and how he might conduct himself. He had a whole lot of time, a whole lot longer than the couple of days he's been in the jail right now. So I'm just not convinced that that's enough. I appreciate your argument. If there's anything else you wish to make a record of, please feel free. But I am convinced that the bond I'm imposing is the right one for this complainant to keep her safe and allow her to participate in the proceedings as she wants to do.
I understand. I appreciate the court, Judge. I just don't think that him doing time in an MDOC is indicative of quiet time, thought time. You're in there, you're fighting for the safe, Judge. It's more of a punishment. And I think that I don't think he should be necessarily held or blamed for certain things that we don't have knowledge of. If I knew why he did the bid, Judge, or what the circumstances were, I could understand and articulate it better. But I appreciate the court giving me the opportunity, Judge, to to respond.
Okay. All right. So he's going to be in front of a judge again, December 26th at 9 a.m. He can certainly ask them to change my bond, and they may do so. It is a high bond in a misdemeanor case, but I believe it necessary to complainant safety. That's probable cause conference, December 26th at 9 a.m. After that, preliminary examination is set for January 2nd at 9 a.m. Let me finish, and then if you have questions, you can ask. Bond is set at $300,000 cash, no surety. He's able to make that bond GPS tether with full home confinement. There is to be no contact with the complainant if he makes the bond, and there is no contact with the place of the offense if he's able to make the bond. All right. Was there something else?
Judge, I have nothing further. Mr. No. Go ahead, Mr. No.
So do I get home to the whole 300,000 or what?
Yes, sir. This is a 300. It may be outrageous. I find the descriptions in this investigator's report outrageous. I do.
I didn't keep
That's why it's
there.
imposed.
I let her go. What are you guys talking about? So can I get a bondsman to do this? Or
absolutely, you can. Absolutely, you have that right.
Okay.
So, all right.
I get
December 26th. 9 a.m., January 2nd, 9 a.m. And yes, you can talk to a bondsman. If you're able to make that bond, as I said, GPS tether, full home confinement, no contact with complainant, and no contact with place of offense. All right.
But hold on, I work in Ohio, so can I go to Ohio to go to work?
If he makes.
Not right now.
Judge, if he
So I
makes,
can't work?
he'd be allowed to go to work.
I can't
So
work?
again, you can address this. You can ask an attorney to file an emergency bond motion on your behalf if you wish to have it addressed. Right now,
Yes,
I have you
I
on a
do.
home confinement tether. Okay, I have a GPS tether on you with home confinement. So you'll have to ask an attorney to file an emergency bond motion for you if you want to have that condition lifted, because that's what I have on there right now. Okay,
Mhm.
all right,
Yeah.
thank you.
Thank you, Judge.